Thank you, Mayor Mercier. We're going to start our first forum, and we've entitled it Government and Agency Forum. We have 4 speakers, followed by a question and answer session. Then we'll take a break. Bev Hendry is the Chief Administrative Officer for the Township of Scugog. And you have to think that the title of her remarks, A Tale of Two Airports. That's really interesting. You have Bev's bio, but I'll just point out a few things in particular. Bev joined the township in November 2005, and in her capacity as CAO has enjoyed community building and been a driver of a waterfront revitalization project in Port Perry, which has included securing over $10.5 million in Building Canada funding. And prior to her time in Scugog, she was the Regional Director, Central Region, for the Ministry of Municipal Affairs and Housing, and had over 19 years of progressive management and municipal experience at the provincial level. Bev, come on up.
Good morning, everybody, and welcome to the Township of Scugog. I'm quite overwhelmed. I'm very impressed with that you all came out, and I think we're going to learn a lot from each other today. So first of all, I'd like to take a second to thank, on behalf of the Scugog team, Rob and the KRCA staff for volunteering to partner with us to deliver this event today. Many hands make lighter work, so we do really appreciate that. I'm also very pleased to kick off today's presentations. My presentation is based on Scugog's recent history with managing fill, and it's based on the story of 2 airports, and I apologize for that literary metaphor, but it is a metaphor to demonstrate the effectiveness of a proactive strategy relative to reactive tactics. I get to work out all the bugs too with the technology. So in my presentation today, I'm going to overview the Scugog site alteration bylaw history. I'm going to talk about the first airport story. I'm going to summarize the lessons learned from that. I'm going to then talk about the second airport story, and then give some suggestions for moving forward. So I promise this will be a quick summary of our site alteration bylaw. Like many other municipalities, it's evolved over time. Section 142 of the Municipal Act gives the municipality the legislative power to pass a bylaw to prohibit or regulate with respect to the placing or dumping of fill, removal of topsoil, and alteration in the grading of land. In 2004, Scugog enacted its first bylaw so that the township would have the ability to control potential impacts to private lands, where other permits weren't available, for example, site plans or subdivision agreements. Bylaw 12504 created a permit application process to prohibit dumping of fill on lands without a permit. In and around 2009 and 2010, the township and our neighboring municipalities started to notice a whole different type of application that was coming forward. In the past, those applications were for things such as a farmer wanting to level out their field. But in the new world, we're starting to see applications for thousands of truckloads of fill from development sites in the GTA and the surrounding area. In June 2010, Council updated Bylaw 5210 and to create a stricter permit application process. And it had clearer regulations with respect to soil quality, security deposits, commenting agency consultation, and requirements for oakages and moraine compliance. Council enhanced the bylaw again this past May, and that was to provide for the ability for the municipality to enter into agreements and to set conditions. So this first story is a bit lengthy, and I've edited it. And for those of you who have been intimately involved in this story, please understand that my approach here has been to summarize the story and to provide the highlights. Some of the other details will likely be addressed through subsequent presentations today. So at 13471 Lakeridge Road, this was a former rehabilitated aggregate pit. In fact, it was one of M&R's showcase rehabilitation sites. It is located just south of the corner of Lakeridge and Goodwood. The owners made an application for the site alteration in April 2010. Our CBO granted the site alteration permit on May 6th, not much time after that. We concluded afterwards that this was likely done in error, as Oak Ridge's marine compliance was not reviewed at that time. Earthworks immediately erected a sign stating clean dump fill site and heliport and began to accept fill. Now, I drive by this site regularly. Lakeridge Road is one of my favorite routes to work every day. I was not surprised when the township started to receive a number of inquiries and complaints from local residents about the earthworks operation on the property. I guess in one way we were fortunate that the site was very visible from the road. Their concerns were about noise, dust, traffic, impacts on the road, impacts on the environment, including wildlife habitat, the groundwater system, and the Oak Ridge's marine compliance. As a result, the township issued an order to Earthworks in July to cease all site activity on the property until the township's concerns about the operation were addressed. So Earthworks did comply, and during that summer, the township and Earthworks and our lawyers attempted to negotiate an agreement to address the following concerns: the quality of soil and the fill deposited on the property, a security deposit for the township, confirmation of compliance of the fill proposal in terms of the Oak Ridge's marine. Earthworks gave the township $200,000 security, and on the strength of that and the negotiation, the township permitted Earthworks to resume the activity at the end of August. Soon after, their lawyer made a presentation to council to request an extended permit to March the following year, and council referred that request to staff and asked for a recommendation. Now, the CAOs are supposed to know a little bit about everything in the township, just a little bit. But this is one of those ones where I had to get a little bit more involved because it was an area that we really didn't have much knowledge about, frankly. In an effort to learn about the business, staff in the municipality asked many resources that were available to us. And a number of you are here today in the audience, and I sincerely appreciate everything you did for us at that time. We consulted with KRCA and CLOCA, and particularly because that piece of property actually crossed both their watersheds. We talked to our neighboring municipalities because they had actually been starting to do a lot of work in terms of managing fill. We talked to our legal services, we talked to the Ministry of Environment, and we talked to our diligent, resourceful, and concerned local citizens. By the end of that September, based on the condition of having a signed agreement with Earthworks and the removal of the heliport sign, council agreed to extend the permit until the end of the year. Now, the next few images I'll show you are going to demonstrate how the operation grew and grew. These are all aerial photos, a combination taken by the local police and militiamen. You can really see it changing the landscape. So by the end of that September, based on the condition of having a signed agreement with Earthworks and the removal of the heliport sign, as I mentioned, council agreed to extend the permit to the end of the year. At the beginning of October, we received a report from our QP stating that there had been an exceedance of the MOE Table 2 standards in one of the soil samples tested. More tests and more samples were confirming the same result over the next few days. On October 8th, we revoked the fill permit on the grounds of the failed soil samples. The same day, the township directed a sign on the entrance of the property stating no dumping allowed. Now, from a CAO's perspective again, the timing of these actions were terrible. 2010 was a municipal election year, and I had a lame duck council, and from September until December 6th, Inauguration Day. And besides a number of the other restrictions, the one that was most poignant in this case dealt with the fact that council had a restriction in terms of spending or incurring a liability that exceeded $50,000. But I have to admit I was fortunate, even with a change of 6 to 7 in our council, we had a really good council transition, and I had really good cooperation between the exiting mayor and the incoming mayor. Shortly afterward, the lawyer for Earthworks wrote to advise that the permit, in his client's view, was not revoked in accordance with the bylaw that had been issued under. And he also advised at the same time that the owners had decided to pursue the long-term use of the site as an aerodrome. And the future filling activities would be based on creating final grades suited for creating a landing strip. And also, these activities were a matter of federal jurisdiction, and they continued to keep going with the fill operations. Many calls were made to federal transportation contacts to determine what this means. We received many responses, but none were really clear. At the time, there was a recent decision on a constitutional challenge regarding provincial planning rights with respect to an airport in Quebec. And at the time, there's a general interpretation that anything relating to aviation is within the jurisdiction of the federal government. That fall, as you might imagine, was filled with public meetings, consultations, political discussions between the three levels of government. And with the support of legal staff from the region, Jason, and through Loopster Nixon, particularly Darren Earthy, the township sought and achieved an interlocutory injunction in the following February, and earthworks ceased their operation. Further to that, the township was successful at divisional court, where the judges determined that it was a stretch to contend that the fill activity necessary to make a former aggregate pit flat for a runway was not activity that was integral to an aviation operation. So the outcome of that case, and this was, again, the township in Loopstra defending against Earthworks and their Bay Street lawyer firm with Clayton Ruby, that in considering the circumstances of the case, the court did not accept that the Earthworks site was an airport, and that the court did not feel that the enforcement of site alteration bylaw, like 5210 in the township, would interfere with the federal works. The case was decided on the first point. Finally, the operation stopped and the operators moved on. This story is not finished, and so far there's no happy ending. Right now we have a site that's partially filled and looks quite unsightly. Almost 2 years have gone past, and we are still not aware of the status of the MOE order or the dirty dirt that was placed on that property. We have not lost sight of this at the township, and we commit to moving forward and making it better. This is what the site looks like today. That's just one part of it, actually. So what did we learn? We learned a lot, but first it became very clear that there is no government agency that has general oversight for the management of commercial fill in Ontario. It is a piecemeal process. We also learned that you need to take time to do things right and to trust your gut. We learned that it's okay to request for securities to protect your municipality. This is a complex and costly practice for a municipality to monitor. And if you ever have a situation where someone plays the airport card or they hang a windsock in relation to a fill operation, just separate the aviation component from the fill activity and deal with the fill. So the second airport story, Greenbank Airways. This story is actually about an existing airport, Greenbank Airways. It's just in from the southwest corner of highways 47 and 12. And I had met with the previous owners, and they had been talking about an expansion plan as well. So I was not surprised last January when I learned that the new owners were holding a public house, and they were going to be sharing their ideas about their expansion plans. I was surprised to learn, however, that those plans included their intention to import fill to expand their runways. At that meeting and weeks after, Council invited the airport operators to meet to discuss a proactive approach to move forward. The discussions did begin, and having that court decision in our back pocket, though, however, made us feel very confident that the mandate to deal with fill was within the township's purview. So based upon some of the best practices and legal advice, many municipalities and the CAs and the MOE, everybody had been working on this issue, and we decided at that point that we needed to beef up our bylaw a little bit more. So we updated the bylaw 5210 to enable the township to enter into agreements to set conditions. And through many meetings and correspondence through our lawyers, the township with the Airways worked together to develop an agreement. In May, with the encouragement of the township, Greenbank Airways hosted another public meeting. This time, they had their consultants in attendance to answer questions and to deal with the public's concerns. So this is, I'm going to summarize our agreement that we have in place because I think it could be a good model to move forward with. The agreement that we have contains the following components. We set out a time frame. There's a notion that for the approval of the QP by the township. There is compliance with the quality control plan, the grading plan, the stormwater management plan, the noise and dust control plan, the hauling routes, the region and MTO permit requirements. There's also a requirement for the owner to share source information and test results. And the municipal director has the discretion regarding source site selection, selected by the QP. There's standards regarding the soil standards, the requirement for regular project meetings between parties, Township's access to the site, and data relating to source sites, their address and the owner, the total fill received, the list of the complaints, and the results of the soil and groundwater tests. The contract also deals with a methodology to deal with dispute resolution, to deal with securities, the liability and insurance matters, and to deal with the cost, the fee per load. The next few pictures show the agreement in action. So demonstrating the directional flow for the haul routes and the ticket-taking process, and actually the fact that we had access to the site to be able to take those pictures. In early summer, the project hit a snag. It had originally been assumed that the road in front was the responsibility of the regional municipality. In fact, MTO owned a portion of the front to the intersection. Greenbank then had to get a land use permit from MTO, and efforts were made by both parties to expedite the work. In July, Council held a special summer meeting, and the decision was made to approve an interim site alteration permit and to sign the agreement with Greenbank Airways conditional upon the MTO approval. And they eventually got it, and the operations commenced in November. We had our first project meeting on last Thursday on site. So this story is not finished yet. We're sort of just moving through it, but as you can see, it's been a little bit easier to tell. The lessons that we learned and acted upon have turned our role from reactionary to significantly more proactive. So our suggestions for moving forward. Incorporating a best practices procedure is a critical part of a relationship between an operator and a municipality or conservation authority. Our contractual agreement with Greenbank Airways makes the expectations clear and therefore more straightforward to manage. Rather than having each municipality and CA develop their own, it would be preferable that a standardized agreement be developed by the province. There's a vital role for MOE to play an issue with such a guideline. The best practice document that's out for consultation right now, Soil Management, a Guide to Best Management Practices, is good, but it's not detailed enough. The other area that we think needs more work deals with ensuring initial soils tests on the host site are completed and that they are compatible with the receiving fill site. And lastly, there is no clear definition of clean fill or dirty dirt. We need a new table designed specifically for this industry rather than using the proxy tables that are the current practice. In conclusion, the field is emerging and evolving, and I look forward to learning more today from the different roles and perspectives that are being shared. So thank you for your attendance, and thank you for coming out.